Hello to everyone. We are starting today on a new topic, a topic a little bit foreshadowed last week when we talked about blasphemous speech. So we will be talking about freedom of religion in a comparative perspective. It's a vast topic, so I have made some choices. We will not look so much about limitations of individuals' freedom to exercise religion. We will be looking more at the issue of state-church relationship. And to illustrate this point, we will look at religious symbols. You have, I think, seen it when you did the reading for today. We will look next week also at case law in Germany. And we will later on then talk about religious clothing, which is also often put into relationship with church-state we will then look also at France, which has quite a different approach from, for example, the United States or Germany. So it's just a part of freedom of religion. It's, by the way, also an area which is in constant evolution, mainly in the United States. And you may imagine why, because we have now a conservative majority of the Supreme Court, so it's quite closely followed. What has the court basically decided with respect to freedom of religion? I don't know, have any of you heard about some cases decided recently? There was one, quite a controversial one, about teaching, instruction in public schools. So a school which had manuals which were LGBTIQ friendly, trying to make sure that it's a constant question, make sure that if you represent a family, it could also be, same-sex family, etc. And parents basically demanded an opt-out on religious grounds, saying, if you use these manuals, we want an opt-out. The school, I think, tested the opt-out for some time and then said, well, it's unmanageable. There's always someone who wants opt-outs and so on. But the Supreme Court basically found that freedom of religion gives you the right to demand opt-outs when there is teaching which could clash with parents' views on homosexuality, etc., their religious views. So that's a judgment which has stirred quite a lot of controversy. Certainly it would be judged quite different, for example, in Switzerland. So just to show to you, it's an area which is moving. But before we look at the United States today, which is the focus of this class and on religious symbols, and just maybe some general remarks. So we will be focusing, as I said, on religious symbols, but then also on dress codes, mainly in schools, but not exclusively. And we will also see that one concept appears quite often in judgments, independently on whether it's the US or other jurisdictions, is neutrality. And we will see that neutrality can be interpreted differently. What it maybe shares that neutrality generally is a positive concept. Generally, people think it's something positive to be neutral. But what does it really mean to be neutral? That's far from evident. And we will see there are different conceptions of neutrality. Maybe just to build on what I just said, when we look at the relationship between state and church, we can have quite different models. We can have, you can see on this spectrum, two extremes: full assimilation, that would be, I reproduced an excerpt from the constitution of Iran, where there is no separation or no basically distinction between the state and church. The constitution itself endorses one religion. The form of the government of Iran is that of an Islamic republic, and it's the belief in the sovereignty of truth or Quranic justice, etc. Certainly something which is not unknown also in Europe in history. It took some time to reach a stage where, well, it was not the ruler imposing one faith in its kingdom. And we can see here an example of a constitution which has nowadays still full assimilation. Then we have on the other side strict separation, sometimes also referred to as secularism, laïcité. I am using it here as a, not necessarily to say this is the French model, but the French model would get closer to that. The jurisdictions we look at are somewhere in between, using often the term of neutrality, but the stricter you interpret neutrality, the more it goes towards strict separation. And the more relative you say, well, neutrality does not mean that the state can never, in a way, cooperate with religions or somehow support them, the more I would say you have a relative neutrality concept. Now, strict separation, as scholars observe, when you push it to an extreme, it can result into hostility to religion, because any accommodation of religion is considered as already breaching secularism. To give you an example, you would say, well, we cannot grant any exemptions from school, for example, for a religious holiday, because that would be against secularism. We would take into account, religion, etc. So I think it's important to bear in mind that if you push strict separation too far, it may then also result into not leaving any room for religion or even hostility to religion. A regime, for example, historically speaking, communism, for example, was very hostile to religion, went even further. So I think mainly because it also viewed religion as a competing ideology. So if you were practicing a religion, that was really viewed with a lot of suspicion. So we are looking at jurisdictions more, not at either end of the spectrum. But maybe just to introduce then this concept of neutrality, as I said, there are different conceptions of neutrality. Generally, when you say someone is neutral, it means you don't take sides, right? You don't, but then it's not so easy to know, well, how will we determine if, government takes side? Do we look mainly at the purpose pursued of a measure? Do we look at the impact? We also have a difficulty that the current legislation is not neutral. Obviously, the legal order is always a reflection of history. I'm giving here the example of Sunday. There's no work on Sundays, which then, as a consequence, can cause some problems for other religions. And this is why you may need exemptions, for example, for religious minorities, because their holiday, Shabbat, etc., is not accommodated within the existing legal framework. So we use neutrality, but we always use it in legal orders, which, and I'm not criticizing, that's just a fact that a legal order will be also reflecting religion and history, religion being part of history. Then we can maybe also think in terms of a little exercise. Imagine you have a school, you run a school, and you have now children who have of two faiths. Let's take they are Christian and they are Jewish, and they want to put up religious signs. What does it mean to be neutral? Putting up no signs, putting up both signs, what would you say? Put up a menorah and a cross, or any idea, what would you say?
Maybe putting up equal amounts of both sides.
So you would say, why not putting up signs of both, but you would have to make sure it's relatively equal. Any other views? Would someone say not a good idea? So. What does it mean to be neutral? Does it mean we have two groups? Well, I'm not taking sides, both are up. Okay. So
yeah, I want to build on that, and I kind of lean towards no sign, but you also, I think in the school like doing like a unit on world religions, in that case, I think all the signs should be put up. But if it's just like um, celebration for the holidays, like I lean towards it should be like ne- neutral with none of the signs.
So let's not put any signs. We have.
I think if we take the USA Constitution in the First Amendment, it said Congress shall make no respecting to an respecting an establishment of religion or prohibiting the exercise of their. So it means they don't restrict. At the same time, they ask the union to promote it. The both sides are there because clearly they have mentioned, yes, you can display it in your private space, but not exactly in the public space.
I'm not sure to be very.
Traditionally, the USA is a Christian-based country, so that's the reality that we have to identify that. But still, they make that the both ways are there.
But maybe just when you say, Congress shall make you cannot establish a religion, it's not so clear what does it mean. It could be interpreted historical turn to that, just to say you don't have a state church, it's not like we are.
I think that both putting up signs and not putting up signs can be a form of neutrality, but I would add that I think it's possibly, like, depending on what the objective is, there's almost more benefit to putting up both in the way of building like tolerance and understanding and knowledge about different cultures and celebrating those cultures.
So you're more in the multiculturalist approach that way, yes? So I came with a simplistic example, right? I was saying it's very easy if you just had, easier when you have two groups. What now we add atheists, agnostics.
I don't think that atheists have this one sign that they can all relate to.
So it becomes more complicated if you add atheism and so on. So anyone else had that?
I wanted to say I'm more in favor of putting up, both signs. Because if I think of a real life example, for example, we couldn't put up Merry Christmas during the holidays. And I think it can be nice and it can be more, as my colleague said before, a diversity thing to see, for example, this period, how it is celebrated between and if we say no signs, then how far are we taking it? Are we also saying no symbols? For example, no cross necklaces or no caps that the Jewish religion uses? So I think, where do we draw the line in the sand if we say absolutely no posters of religious content are allowed?
So you're saying, and we will also look at religious clothing. Is it when we say the students can wear a cross? Is that a violation of neutrality?
But then again, I think it's important to put neutrality in its context. And when it comes to ourselves and what we practice, that's another thing than putting up signs in a public institution. I like to make the difference because, to me, the word neutrality is very hard to define when it comes to religion because nothing is neutral when it comes to a multicultural society. After, like my colleague said earlier, it depends also what goal you're trying to reach. If we're trying to have a tolerant society, then yeah, maybe exposing people to things is important. But to me, putting up signs in an institution is very different than clothing because clothing is very personal, and that's where I lean more towards we should be tolerant to other people's way of living, as long as it doesn't transgress my way of living. But yeah, again, neutrality is very hard to define in these contexts.
So just to be, okay, I'll give you the floor.
You cannot separate law completely from the society. That's the issue. They are trying to make the law as separate things. So the thing is, law make it based on the societal norms, and the acceptance. So we cannot reject the people's beliefs. They were practicing for a long time because the religion, the ideology of religion, which comes from the different side, even being non-religious, atheist, it's also a form of religious ideologies. So there should be a balance between that. You cannot completely separate from the religious
And this is a topic which comes back in the dissent. You read Justice Scalia's dissent. So my idea here is not we will touch about very different issues. We see very different interpretations of what neutrality means. This example, which I agree is simplistic, are two religions. It was just to make us reflect that it's not as easy to define. I think probably if I ran a school on practical grounds, I can very well imagine it, particularly if there are tensions, that you will, once you start putting up signs, you will have endless debates. Who has more signs? Where are they placed? Has one group a bigger sign than the others? But there has also been the argument saying you put up nothing, you favor atheism. That's a symbol, you kind of ban the religion. Some people say, well, atheists maybe have also some signs they could put up. There is a sign for atheism, etc. But just to show, as I said, we will look at more. I think there are different answers depending on the jurisdiction and the issue. Do we distinguish, closing? By whom? By students? By teachers? Does it make a difference? Is that different from erecting symbols in a classroom? So we will look at all these issues. And as mentioned, my aim was just to say, well, we always talk about neutrality, but what really it means is not that easy. And you will find different positions. And also, if you say state neutrality means you can never somehow take, any action favorable to religion, you may have difficulties then with people's rights to exercise freedom of religion. In McCreary County, the Supreme Court gives some examples. Imagine, I'll give another example than the one used. People are in detention, and you will maybe let them or even give access, to chaplains or to help them organize a ceremony, because you say, well, these people otherwise will not be able to practice their religion, or the military service, or people in hospitals. Or you have aumônerie in a university sometimes. So you may have settings where you say we have to somehow encourage or support religion or pay even the salary of people, of chaplains, whoever, can be also people of other religions, because otherwise people will not be able to exercise their religion. And there is basically, maybe just about detention, there is a case by our Supreme Court where basically they allowed ceremonies for Christians but refused for Muslims. And our Supreme Court said you have to look at how many people there are. It's maybe understandable that if you have one person of some, very minority religion, you may not hire someone, but the Muslims were quite strongly represented about equally to Christians. That was a violation of neutrality. But that is quite understandable, I would say, but an easy case. So we will be seeing how neutrality plays out in these different contexts. And today, looking at the United States, someone already mentioned that when you look at the First Amendment, you have basically two elements, what is called the Establishment Clause and the Free Exercise Clause. So the Free Exercise Clause, it's really letting the individual live according to his or her faith, prevent the state from interfering with freedom of religion. This is not what we are looking at. For example, the case I mentioned at the beginning about opt-outs from schools if you think textbooks are too favorable to homosexuality, that would be a Free Exercise Clause problem. The Establishment Clause, well, you don't establish a religion. I mentioned it before. It's not so easy to know what it means. A minimal meaning could be there's no official church. But basically, interpretation also has varied over time. There are different models in the case law, and this is a simplification, but maybe a few models we can distinguish. One would be strict separation, which the Supreme Court mentioned in one case, saying that the wall between religion and non-religion should be kept up straight. It's a key, kept high and impregnable. So I would say this is a sentence the court does not use anymore so much. So the idea that it's really a wall between religion and non-religion, an impenetrable wall, is not really applied, I would say, but it is one way to interpret the Establishment Clause. In Everson, basically, where the court used that sentence, the question was whether whether the state can reimburse or can reimburse parents for the costs of basically of transporting the children in a bus to schools, and the schools were religious schools. And basically the Supreme Court admitted that, saying, well, here, do we pay for the bus? It's to protect the children, it's to protect their safety when they go to school. But it had to be given to the parents and not to the school. So that was still compatible even with this strict separation. I mentioned, maybe I just go one slide back, different models. We will look at the neutrality model and a third model, which is accommodation, which I will also give you an example of. I would say nowadays we are rather in the accommodation framework. The neutrality framework, which we will be, which was still, I would say, prevalent in McCreary County, has been abandoned since. So we looked at strict separation, and maybe I just mentioned we can go in that. The neutrality framework is linked to this Lemon test, which you have, which appears in McCreary County. And there was also another test, you know, that in the US they love tests. A judge writes an opinion and says, well, I suggest this test, but in my view, the symbolic endorsement test certainly overlaps with the Lemon test. It was Sandra Day O'Connor which coined that test, basically by saying, what is the problem in a way if the government takes sides in religious matters? And what it says is basically, you can see it more down here, you send the message to some people that they are outsiders. So if you're a religious minority and the state keeps reaffirming, that's usually what happens, it's rare that the state reaffirms minority faith. It basically says to the others, you are not a full member of this community. If I take the example of a school, imagine a school setting where you will have symbols, but just of the majority religion, a child might then legitimately feel in a way, I'm not part of this community. So that is the logic between this symbolic endorsement test. And the question was also for Sandra Day O'Connor, well, how do we identify if the government takes side? And she basically referred to a hypothetical observer who is presumed to possess a certain level of information that all citizens might not share. So, you know, history, etc. We will return, we'll discuss McCreary County a bit later. And then there's a third paradigm, which is the one, I would say, which leaves the most room to religion. And basically, it says the Establishment Clause does not prohibit the government to favor sometimes religion or some religion. It doesn't hermetically close, the society to the religious influence, but the line in the sand is it's coercion. It's all about coercion. Government must not coerce its citizens to endorse a certain religion. We will see that this is a paradigm we find in other jurisdictions as well. The question then is, what does coercion mean? How do we interpret it? Could someone think of an example how someone can be coerced in religion? You are forced to, yeah. So it could be, it's a good example saying, if you want to work for the state, you have to be, I don't know, Protestant. Let's take that as an example. So that you could say, well, that you lose an important benefit. You cannot work for the state, so that's a form of coercion. I mean, you could think of the most extreme form of coercion might be criminal law, that you will force people to have a certain or endorse a certain religion or be member of a certain religion. Otherwise, you get into trouble. You can have withholding benefits. Can someone think of more subtle forms of coercion?
Actually, I was wondering, the example I have in mind is a form of coercion, but it actually happened in Quebec. They used to give teachings of the Bible as mandatory teaching since we were young children, and eventually a law passed that wasn't allowed anymore, and we went from Christian teachings to all teachings. But I was wondering, because the problem was that we didn't have any other option for the children that weren't Christian for a long time. And I was part of the generation who, a year we had like Christian teachings, then the year after they're like, oh, it doesn't exist anymore, now we have all religions, which I was worried.
So you would say, probably the argument would be that it's a kind of indoctrination, that
exactly, not coercion in that case.
And usually you also have freedom of religion is also the right not to be compelled to be part of a religion, yes?
So the way this was arranged in my country, Hungary, which is traditionally more conservative and more Christian, is that we looked at the Bible, as was said by my teachers, not necessarily as a religious object, but as a literary object. So, for example, we also studied the Bible during literature class, as you know, to see the literary aspect of the things. And I don't know for you, was it like history lesson?
Oh no, like it was Bible lesson.
Oh, okay.
Oh yeah, it was straight up
No,
like
it is.
Bible lesson.
So maybe what human rights law has to say about this, it's to say the state has two options. Either it can be science of religion, but that means it has to be neutral and pluralistic. So you would have, if you go, it's a class explaining, you know, what's the origin and the main phase of Christian religion. You compare it to Islam, Buddhism, whatever. You can maybe giving a bit more space to the religion of the country. That would be okay. But if it's taught in a way, you know, you focus on one religion, and it's really not objective presentation, but you should be, it's a religion teaching, then you have to grant opt-outs. Because otherwise it's a form of indoctrination. Obviously you may have then borderline cases, you know, what is, where does it, and there were cases one about Norway, where basically they said, well, it's more of it's a class of science of religion, but they mainly talked about Lutheranism, and the court felt, well, no, actually you are instructing people to be Lutherans. There was a case against Turkey, and there it was, the students had to repeat and memorize, it was only about Islam, and also verses of the Quran and the surahs. There the court also said this is not objective and pluralistic. This is basically teaching one religion. And if you want to do that, well, then you have to grant opt-outs. In Switzerland, we have different systems depending on the cantons. Geneva is secular, so there is no religion instruction in school. In other cantons, like the one I grew up, I remember we were divided. It was about half kids were Protestant, half Catholics. And so you had one group went for the Catholic instruction, the other for the Protestant one. But then you need to grant opt-outs. It's not, and there's case law, for example, some schools said, great, well, no problem, the other children just stay in the classroom and they will do drawings. That was not considered admissible because it's saying, well, you're still exposed to it. You know, you can't force the child who is, I don't know, Jewish, atheist, whatever, to listen to these Bible lessons, as you called them in Canada. So no, you have to be able to leave. And then, I don't know, the Hungarian example, maybe the question is how much time you spend on Bible study. I could imagine, you know, you use it to show a literary device, but if all your literature classes are mainly about the Bible, then it would raise questions. Our Supreme Court also, it was the question, can you sing Christmas, you know, and so on, songs, and it said yes, but it can't be done. If it's now all year round, the religious songs, that would not be okay. Where you draw the line, then obviously. It can't be in an excessive way, our court said. So just to come back to accommodation, I would say one major challenge is to say, and we will see different interpretations, what is sufficient, amounts to coercion? Is any indirect influence already coercion? If you push it too far, then it could mean that you can never mention even religion in school. You can't, whereas, okay, it is part of our history. And I will give you an example where this was exactly controversial in the Lee versus Weissman case. It was about a high school graduation, and the school had hired someone to deliver an opening prayer, which was conceived of as very inclusive, so not, clearly targeting one religion. And the Weissman family basically asked for an exemption for their child, saying, look, we are non-believers, so any prayer we don't agree with. The majority of the Supreme Court found that if you have to be present, during the prayer, this is a form of coercion. They also mentioned there is peer pressure usually that, for example, you would still feel probably as a child if the others get up to join in the prayer, you should kind of participate. This was not this, but there was a dissenting opinion. Any lucky guess who it might have been? Scalia. So Scalia basically said, well, in his way, from his point of view, this is not sufficient for coercion. So this subtle coercive pressure, indirect coercion is not enough. Basically, his point of view was to say, well, that this was ludicrous, I quote him, to say that anyone who sits in respectful silence and to think that person has actually joined in the prayer, that would be ludicrous. We indeed live in a vulgar age, but surely our social conventions have not coarsened to the point that anyone who does not stand on his chair and shout obscenities can reasonably be deemed to have assented to everything said in his presence. So in his view, there is no subtle coercion. It's basically just that the child also, in a way, shows tolerance for other people's religious beliefs. So I don't know how you would have decided that case. Grant an exemption or say, well, it's not a form of coercion. Anyone on that? No ideas? We will see. We will have different interpretation with coercion. I said the neutrality framework, the difficulty often is what is neutral? What does it mean to take sides? If you take the coercion framework, it's not so much about neutrality, but then you have the difficulty of saying when have we reached, sufficient influence that it's coercion. So, for example, is it coercion if, let's take an example, someone wears a kippah. You're in school and you have a child, a turban, a Sikh with a turban. Is that a form of coercion on other children? What would you say to that?
The child is wearing or the teaching?
We could take both cases.
Well, in both cases, I would lean towards what my colleague said earlier about tolerance. Like, we live in a society where people wear and practice different faiths as long as you're not putting it on someone else, it's not mean that you have to wear it. I don't see it as a form of coercion, I see it as a form of tolerance.
Situation is changed if you are living in a multicultural society, especially if you are in a majority area, but you are not belongs to the majority. But if you are trying to showcase it or willingly or not willingly, it might be causing tension between these communities. So we have to be sensible about that side as well.
So you say it may be different if now you're a minority and you would have, imagine all your teachers come with a religious garment, you're the minority.
Take a lot of samples from the Asian countries, especially in South Asia and East Asia, dealing with that. There was one case, a foreigner, I don't know who it came. She came to she came to Sri Lanka and she wore like, it was looks like a Buddha statue in the head, Buddha's head.
On the head.
Then it was noticed by somebody and, made a complaint saying she's actually disrespecting Buddhist religion and wearing this kind of, such kind of dress. Then we checked that. Actually, it was not a Buddha statue. It was like in Jaina Mahavira. It's similar case like in
Okay.
India. If you go to India, in their religion also Jaina Mahavira shows like.
It was Jainism, okay.
Jainism.
Yeah, Jainism.
And the other one was like we think the chakra, that the Buddha is one of the symbols, but actually it was not the Buddhist chakra.
Okay.
It was was what we call the ship anchor. Actually, it was not the anchor. I remember the wheel.
The wheel of the symbol of the Buddhist.
That's great, but it's much similar to the Buddhist symbol. So it was a simple thing, and it is not a thing that we should take care of things, but people really care about that. It's not because they are really interested in, they do really respect their religion, but they are always sometimes looking for a fight.
So I think what I take out of what you've said, I think often these things are also contextual and you may not find one size fits all. If you are in a context where you have, for example, very strong opposition between communities, you may have to act differently than if you don't have, if it's not very tense, or if you have, what is the composition, majority, minority, etc. But it's certainly astounding sometimes what lengths people can go to provoke the other. I mean, if you look also, I once did some research on the first cases on freedom of religion in Switzerland, that it's quite, now between Protestants and Catholics, it was quite amazing. I will do a procession just in front of the Protestant church heart, and they will get upset. And so it can be really difficult. I think of Northern Ireland, certainly at some point, also a very complicated context. But why I mentioned wearing religious symbols, we will see, closing, that courts interpret this differently. The French way will be, in a way, that is a form of coercion already on other children. And we will see a counterexample, the German Constitutional Court saying, no, actually, that has nothing to do with coercion. That would not go far enough. And we will see the same thing in terms of religious symbols in school. A cross, is that a coercion of children? Or no, actually, it's not a form of coercion. So just to sum it up, we have, for the US context, different paradigms. We had strict separation, actually not that much used, and then neutrality, which we will look at in respect with McCreary County, with the difficulty, what does it mean to be neutral? Accommodation, I think nowadays the Supreme Court very much leans towards accommodation, but the question then is, what is coercion? It's not a self-explanatory term. If you are in favor of subtle forms of coercion, you may maybe also think particularly, might be different also for children, depending on the age. And peer pressure, I think, for adolescents can sometimes be quite strong, that you want to fit in. Now, let me just mention a few cases. We have now talked about freedom, no establishment more generally. There have been before McCreary County cases already on religious symbols. And I think we need to know these cases to understand also the reasoning of the Supreme Court. So one case, and I tried to find the picture, it's not a great one, that is Lynch versus Donnelly. It's a Christmas display where you had objects like Santa Claus, a Christmas tree, reindeers, colored lights, banner reading Season's Greeting, and a nativity scene. Yes, there is a nativity scene, but basically the Supreme Court said this is no violation of the Establishment Clause. Yes. I think it's that actually, that's what I found as a picture for that case. So outside somewhere, it wasn't in a court building or so.
It was on like a public ground?
Yes, I think it was public ground. And here the court looked at it always from the vantage point of neutrality. But then there was another case, basically, where you had two displays. A display of a nativity scene in a court entrance that was unconstitutional, clearly supporting a link to Christian religion, and the exhibition of a menorah next to a Christmas tree and a sign containing a tribute to liberty was constitutional. It was these two signs. So the court felt the nativity that is clearly supporting Christian religion, whereas the lower display, it's a combination. We have a Christmas tree, we have also another religion, and a secular sign. So you can see you have quite different outcomes, always based on where is the symbol, is it just one symbol, etc. And I know that some people have, I read one critique saying, well, now the Supreme Court has become an interior designer. It will always look at the composition, what stands where, in which size, etc. And some scholars have also came up with this the three plastic animal rule. So if you put, what does that mean? So if you have a reindeer and I don't know, some other plastic animals to illustrate Christmas, secular Christmas, you may get away with a Christmas tree or a nativity, etc. But you can see that it's very contextual. So you have to look at each display and wonder what is the overall message? What was intended? Was it to promote the religion, or was it more to say, well, nowadays, Christmas is also a secular holiday, so it depends. And the rule of the thumb, three plastic animal rule. I had one more case I wanted to mention, which also, a question which arose was, can basically, there was the KKK which wanted to erect a cross on public space, and the question was, would that violate the establishment clause? There the court found that that was not the case, because it was a sign not by the state, but by the KKK. We could obviously then, we looked at it from the vantage point of freedom of expression. That would not be a problem either. You remember that the KKK can even adopt a highway, because you cannot distinguish based on content. But I think the two main cases relevant to understand McCreary County is Lynch versus Donnelly in County of Allegheny, where the outcome basically varied on what signs were up in which combination. And you have actually read two cases for today, and why also these two cases? It's interesting that you have two similar cases about the Ten Commandments in different places. Once it's on the Texas Capitol, and once it's in a courthouse, and you have a different outcome. And one question I asked you was, do you think that this different outcome is justified because there's factual differences, or is it actually unprincipled? When you look at the justices, you could see quite a clear split. You have always 5-4. The conservative on one side, the liberals on the other, and one justice who changed camp because he felt that the cases were not comparable. I suggest we start discussing the cases after the break. And I'm quite curious to hear your point of view. Do you think the cases are comparable, so it's an unprincipled distinction, or actually we have differences justifying a different outcome? Moi, jamais also. So let's resume and discuss these two cases about the Ten Commandments, maybe by starting with first the McCreary County case. There you have, maybe we could do a bit of brainstorming about the case. What are the elements you have retained which seemed important to you? Also, did you agree, not agree with the reasoning? Anyone? I can see some people thinking, should I say something?
So this case, well, the first one, sorry, McCreary County, was two county court notices posted the Ten Commandments, and the ACLU sued and went for preliminary injunction on the grounds they violated the First Amendment. The counties then changed the displays and said their intended purpose was kind of the legal political history, and added a few other documents. That's common denominator among them was references to
Why do you think they added some documents?
Yeah.
What was the idea? We start, first it's the Ten Commandments, and now we start putting up other stuff?
I think the idea was to make it like have more of a secular purpose, which I think is the London test. So by having like various aspects of the political legal history of the United States, then it's not just the Ten Commandments as like a religious purpose.
And think of the precedents, the 3 plastic reindeer rules, etc. So I think they then had lawyers saying, let's make sure that we put other stuff around and then we get away with it. So we had the second display and.
But the district court didn't buy it. They said there was a religious purpose. I think part of that was because the ceremony when the Ten Commandments were originally put up included like a pastor at the ceremony, and like it didn't seem to it had a religious purpose. But the counties then changed the display a bit, a third display where they changed the additional documents, I think, and they put in additional information about why all the different documents were relevant. But that was like the district court maintained that that was still a religious purpose, and they upheld the injunction. So then it went to the appeals court, and the appeals court agreed, and that was kind of the history of it.
But I think that's really the specificity of the case, that you have 3 displays, right? First, just the Ten Commandments, and I think there was a accompanying resolution also with a religious content. A second with other monuments, a pastor, and you keep this resolution. A third one, and I think it may have played a role in the outcome. Then the question was, how did the court, what was the principle, or you mentioned the lemon test. What is this lemon test? What did the court actually examine? Has nothing to do with the fruit, huh? It's,
I think it was whether all government actions should have a secular purpose, and if there is a non-secular purpose, like a secondary religious purpose, that is all right. But there first has to be a secular purpose that is valid in itself, and it's not just created so the other purpose can be justified.
So it's insistence on the purpose, and actually the test has 3 parts, and the court only looked at the first one here because that was already enough to say it's basically 3 conditions which have to be met. First of all, the government action must have a secular legislative purpose, so it's a secular purpose. That's what the court looked at. But then second, imagine you have a secular purpose, the court will still look at the government's action must not have a primary effect of either advancing or inhibiting religion. So it's not just purpose, it's also effect, so impact. You will look at what is the impact on religion. Does it actually advance? The primary effect is advancing or inhibiting a religion. And the last part is, so that was the first its purpose, then its effect, and the third part is the government's action must not result in an excessive government entanglement with religion. So I'll just say it again. It must not result in an excessive government entanglement. What does that mean, an excessive government entanglement? Many of you are not English speakers, so it might be good to clarify. What is an excessive entanglement?
I would say maybe if the government's religion becomes so intertwined that you can no longer tell which one is which, not two clearly defined aspects, they kind of become merged and intertwined.
So I think you've given a good synonym, intertwined. So enmeshed, you can't really distinguish, religion and state. And actually, in the Lemon case, it's from a case Lemon versus Kurtzman, the court felt there was excessive entanglement, and it was about a law which allowed to reimburse non-public schools, and most of them were Catholic, for teachers' salaries, textbooks, etc. There, the court also felt that is too much getting, entangled, even if they do also probably have a public service function. So a three-pronged test, and that's also maybe just why I put it on as something different. I had mentioned before the Lemon test and the symbolic endorsement test. The symbolic endorsement test just focuses in a way on one part of the Lemon test. It doesn't talk about entanglement, etc. So that's why you have to treat both separately. Now, when we return to Lemon, there it was mainly about this first part. That's what the court looked at. What was the criticism against the Lemon test? The Lemon test has been quite controversial for some time. Mm-hmm. How do you then find out the true purpose? Mm. So basically the county said, look, but purpose, what is purpose? We don't know, right? It can be very well hidden. It can be, have a legislative body. People have different purposes. How do you generally establish purpose? So we should basically do away with this test. Because purpose in a way is unknowable. What was the court's answer to that? Was the court willing to follow, to say, okay, we're not looking at purpose anymore?
The analysis on purpose is not kind of subjective reading of the state mind or the officer's mind, but rather an analysis of the factual statements of history, of the context surrounding the enactment of religious acts.
So the court did say, as you said, it's not a subjective thing, and that is actually quite true, that purpose is often used in interpretation. What was the purpose of the legislature? Or they refer to discrimination law, that often you will also say, is there a discriminatory purpose or impact, etc. And so the court says, I think it's quite interesting the way it's worded. It's certainly much more colorful in wording than the Swiss style is quite sober when you write judgments, saying, well, actually, no, it doesn't mean we put everyone on the couch and we do a psychoanalysis to find out the purpose, of the individuals who took the decision, but it's, as you said, more looking. But how will you then determine, if it's not subjective, you look at the history, etc., the court proposes a test, a perspective, how to establish So it's the idea we try to objectify the test by taking the perspective of an outside observer. So it's not what were you actually thinking, it's not that what is really relevant, it's to think how does someone from outside perceive it, knowing. Now, it's also quite common to use such tests, for example, for interpretation, to say often also is something defamatory or so a statement. Courts sometimes say, well, we will take the average reader, the average person. How will they basically interpret something? Now, is that what the court does here, saying we just take the average citizen, okay, the average person walking by? Would they actually see these 10 commandments and say, ooh, this is really, an attempt to advance religion?
They also took the history into account, saying that the objective observer in this case would also know the first and second attempt of hanging up the 10 commandments, because the objective observer is not a blind observer.
So I think this is really important. It's not the average citizen, but it's someone who knows the whole history. So important in this case, you would know the whole first display, second display, third display, etc. Now, what do you think about this? Is that a good way to say you have this well-informed observer, which, let's be clear, I mean, the average citizen will not have that knowledge. Probably most people will not even see the 10 commandments buried with all these other signs. Would you go with a well-informed observer or say, why not take the average citizen? Any preference on that? You sit on a court, you have to decide something. You have the challenge being brought, say, look, this is ridiculous.
I see the logic of like the expanded reasonable observer here, where it's like they need to expand it because if they don't, then there's going to be like religious indoctrination almost like in disguise, and that's what they're trying to guard against. But I think in regards to like what the dissent is saying in the other case, there's like a lot of arbitrary line drawing of like what is like what has a secular purpose, what is too extreme, and I keep thinking about the example of like the Supreme Court upholding the Sunday, the no work on Sunday law, and it just feels like they're arbitrarily trying to like line draw.
So I think we do have an issue of line drawing. How do you draw lines? And we will return to that when we talk about the dissent. And you said you understand the logic. I think the court, in a way, wants to send a message to say, I don't want, any. It's finished with trying to put up religious signs and trying, to think, well, you get away with it just because if you run into trouble, you change it again, etc. So, but in terms of someone else, somebody raising your hand.
I agree. I think the well-informed observer is maybe the better way to go, because I think there are other factors that are readily observable or knowable, and those should be considered as well. For example, in this case, the use of the pastors, the original ceremony, the history of the case itself, and different steps that the legislator went through are very important, I think, to knowing their purpose beyond just seeing it in the corpus.
But it's certainly an approach which is designed to say we don't want any more of these signs and we don't want to be taken for a ride maybe as well. I felt this. Did anyone feel this in the judgment that the Supreme Court was also a bit, they take us for a ride here with the 1, number 2, number 3 displays? And never forget, judges are humans as well. So they can sometimes feel like you'll see that when you'll be in practice. It's good to have the judge on your side emotionally as well, and they don't like it if you take them for rides. Why do I say I think the Supreme Court signaled here, you're taking us for a ride, you just keep coming back with the same thing? I have to find the... For example, page 232, they said, once the countries were sued, they modified the display. So that is a subtle hint, yes, you did that because you were sued. And page 233, you have, they also say after the counties changed lawyers, they mounted a third display. They have new lawyers, they read Lynch and Donnelly and company, and they now know the Supreme Court is an interior designer, so we try and rearrange things. And also, page 233, they say, well, in a way, these new statements of purpose were presented only as a litigation position. So I did feel a bit, it's like, come on, it's sociologically speaking, maybe also surprising to how much effort this county went to keep up these 10 commandments. I mean, I would think 3 displays with different things. So the court clearly does take the history into account, and I think that that has been decisive probably for this case. It's a very strong saying, well. And about the observer on page 230, the court clearly says they don't want an absent-minded objective observer, but they want a reasonable observer who knows the history, the context, etc. And such a reasonable observers have reasonable memories, so that they reject this point of view. We would take just the average citizen, person walking past and not noticing. What about the argument saying, but sometimes you may hide the purpose so well that no one notices it? Even a well-informed observer would not notice a religious purpose. So in a way, the cleverer government is, the less you, what do you think?
But then there's no issue of indoctrination, no? If the underlying message is so hidden that even the very informed observer is not aware of it, then what is at issue? What is at stake?
And this is what the Supreme Court says. Well, actually, if it's so well hidden that no one notices it, it's not a problem. Maybe what the court refers to it, and usually here it uses a neutrality framework. It refers to neutrality quite a few times, saying that Lemon is linked to the neutrality rationale. It does not mention indoctrination. This is not so much the issue, does it coerce or influence anyone? But usually the neutrality framework is justified based on the religious peace. It's to say once government starts taking side, it actually creates tensions between religious groups, or it makes, also this argument, some people will feel like outsiders. You signal some citizens who have the right religion we favor, they are, more worthy than others. And the court, for example, on page 226, mentions neutrality twice. It's always the right-hand column, and then also says, well, that rule was introduced after decades of religious war. We need religious tolerance, and quotes the non-endorsement test saying, well, there is this message sent to non-adherents that they are outsiders. So I would say neutrality is more this peace function. Let's not have divides between communities. A message of exclusion can lead to problems. And I just wanted to give you where the passage was that if it's not page 228, it's on the column at the right-hand side, where the court says, well, if they have been so smart to disguise it so well that no one notices it, it's not a problem, because it doesn't, it's not a divisive announcement. A secret motive stirs up no strife, so it will not create problems. Yes?
On this kind of point, it almost seems pointless to include this, because if something was so well hidden, it's unlikely it would make it all the way up to the Supreme Court. That if it makes it up that far, clearly someone has noticed it. So then it wouldn't be a hidden purpose. So this kind of seems like a irrelevant, in a way, kind of statement. That what is a hidden purpose? Someone's already recognized it. That person hasn't been well informed enough to see it.
I think you're right. Otherwise you probably wouldn't have. You wanted to say?
the fight that the both parties has to do with the court hearing you also have to the final say on the Bible, not on the Constitution. So I feel like it's kind of like curious things, but
So you're saying in a way we are in an incoherent setting. We will make a big fuss about the Ten Commandments, someone worried, but in other settings the religion is still there.
we have to understand we cannot completely agree on the system that we are.
So this is, we can then shortly turn to the also dissenting opinion, but the court here is an example. There haven't been many cases where the court would say, you know, there's a practice which is unconstitutional because there's a religious purpose. Here we have an example, and I think it did play a role that we have had these 3 displays, and the fact that the well-informed observer knows the whole history makes the court conclude here clearly we have a secular purpose. The court also said, I don't know if you saw that, that the display was incoherent as such. Even the last display saying, look, this doesn't make as an overall display a lot of sense. We could clearly see the court wanted in a way to just make sure that it didn't want to be taken for a ride either. So we have here an application of the neutrality framework, and we have a dissent by Scalia. So what were his main arguments? And maybe also a question, are there arguments you agree with, you disagree with? There's quite a few arguments. I personally, that's my opinion, can relate to some, but there's some I can't relate to, I would say.
Yeah, I think the main thrust of his argument is like his originalist perspective, where he points to like George Washington and some of the early American officials and how they used religion in their offices to try and point that there was no like concept of complete neutrality at the origin of the Constitution. And so he tries to expand that principle by saying that the First Amendment doesn't mandate neutrality, and then his originalist perspectives becomes more inconsistent when he broadens like the scope of religion from like just Christianity to all of monotheism, and I think the majority points
That out.
where he's like originalist sometimes, but then expanding concepts other times, and so I don't really agree with what he's doing, but I think that's the thrust of it.
So I think certainly we do find he's a representative of originalism. So you should interpret the Constitution according to, you know, the way, what were the founding fathers thinking at the time. So originalism is often defended as supposedly apolitical, saying we just have, in a way, the Constitution fixed in time according to the founding fathers. There's quite a lot of literature on originalism. I would say one thing is that it's very hard to apply consistently. So it is often then used selectively in certain cases, but not in others. I mean, particularly if you have technological change. Think of Scalia and video games. I don't think the founding fathers would have anticipated anyone having video games, and that would be a form of speech. And here you pointed out to some inconsistency, saying that I think he has a point saying, if you are originalist, that the founding fathers were probably religious and thought of religion. But what kind of religions would they have had in mind, you think?
Different denominations of Christianity?
Mainly Christianity, because that was also the history was different. Christian faith, people fled to the US because they were persecuted as Christians. The first Swiss constitution was also interesting. It protected freedom of religion just for Christians. And that was changed later. So, but it was, well, Switzerland was created after a civil war, Catholics versus Protestants. And Scalia then, as you said, broadened it and said, well, actually, the founding fathers had in mind monotheistic religions, which very hard to demonstrate that. So you could attack originalism by saying the interpretation is flawed. They probably thought of Christian religion. And Scalia then says, well, we have no problem because, what do you think of that argument? 97% of the US population adhere to a monotheistic religion. Is that a good or a bad argument? I think if you say that fundamental rights often are counter-majoritarian and they need to protect minorities, it's quite a surprising statement, I would say, to say, well, as long as 97% are happy, a numerical argument. And
but doesn't this contradict a bit with what you mentioned in the beginning of the class?
You mean the...
ruling that it was acceptable if there was... It would have been acceptable...
You mean the prison case? I think maybe there is a difference because it's state resources you have to, it can be costly. But then you say at some point it would become too costly. But I agree there's also a majoritarian thing. But to say you can't put up displays just of 90, 10 commandments, that's not actually also the taxpayers' money, probably organizing these ceremonies and having... So that's where I see a difference. And what would be the opposite of originalism, another way of interpreting the Constitution? If you're a non... I'm also turning to the Canadians and the... What do you call it?
In Canada, we call it the living tree doctrine, the idea that we planted a seed in the Constitution that can grow and expand and change. I think a living Constitution is similar.
The living tree, living Constitution. The European Court of Human Rights talks about a dynamic or evolutive interpretation, saying in a way, and that approach will say the Constitution was meant to last, and you have to interpret, always fundamental rights in the light of present-day circumstances. So if, for example, there can be technological change, well, nowadays we do have video games, we didn't know them in the past, or we have email, that's a form of correspondence. If, the human rights provision just talks about protecting correspondence and not communication. So you will take into account technological progress, but also that society, for example, also courts will often refer to the evolution of how society perceives certain issues, for example, LGBTIQ, very different, or the death penalty. The Supreme Court sometimes said nowadays, certain forms, minors executing minors, that's not okay according to our days standards. So you have on the one hand the living tree interpretation and then the originalism, which in a way freezes the meaning of, or tries to freeze the meaning at the time of adoption. I say, is anyone from Austria? In Austria, the Supreme Court, the Constitutional Court had a doctrine, but not for fundamental rights, mainly for competence disputes between the federal entities and the federal state. And they call it the Versteinerungstheory, the theory of petrification. So you freeze, it's a monument frozen in time, and you don't make it evolve. So clearly we can see that Scalia is an originalist. And so that argument, you may be on principle in favor or against originalism. If you are an originalist, you might still disagree with him because of, I would say, the interpretation about monotheism. And if you're a living tree person, you will say, well, nowadays we are in a multicultural society and we have to take into account that, yes, we will have other religions, not just monotheistic religions. And freedom of religion has to accommodate all these religions. We can't, it's not an argument to say, well, 200-300 years ago, what were we thinking? That was one argument he made, but it was not the only argument we find in his...
One argument that he made that I did sort of agree with was that he was kind of critiquing the way that the neutrality principle has been kind of inconsistently applied by the Supreme Court. And he discusses how it's been more applied based on the instinct of self-preservation of the court, in not wanting to push against the desires of the majority too much in the elected democratic branches of the government. And I kind of agree with this because it was mentioned earlier the Sunday law that kept businesses closed on Sundays for non-religious reasons, and then as opposed to these two one case, so on the same day I learned recently, that, having the Ten Commandments in the courthouse is unconstitutional, but then having them on the state lawn is, I think it's inconsistently applied, and I think he makes a good point as to.
So I think he makes actually two arguments. One is the practice is inconsistent. Why is it inconsistent? And this, you mentioned it a few times, that religion is not divorced from society. Law is not divorced from society. And if you look at studies, I've seen studies about, how many believers are there, strong believers. Certainly the US comes out as with a lot of believers, rather, if you want to use the label, more conservative. In Europe, there's big differences as well. The Nordic countries tend to be more atheists than some other countries. So religion and how people relate to religion can sociologically, that's a sociological fact, be quite different. So you are in a context where religion plays a big role. And Scalia says, in a way, the court knows it cannot push out religion everywhere. So the question is, how do we, it's not just that the founding fathers were devout, but nowadays social reality is such that there's a lot of signs of religion, and he gives quite a lot of examples. The presidential oaths, the coin, on the coins, etc. And then he says, well, okay, if the court is not consistent, this is also, Scalia is very much in favor of clear rules. He doesn't like balancing. He says, there's a statement where he says, well, we want clear rules. We don't want, in a dictatorship, that's thumbs up, thumbs down. We never know what the court will decide. Looking at the case law, he identifies one criteria where he says maybe, that's about what we can find in the case law. What would that criteria be if something, a monument has to go or not, or a practice is... Basically, Scalia says, at the end of the day, if it's an old practice, we won't question it. It's tradition, we leave it. And if it's something new, basically, we can understand why would the court have taken this approach, is to say, well, maybe they don't want to go and be accused of, if you're really consistent, you want to make religion disappear everywhere, you will also just destroy a lot of cultural property, etc. So there was a tendency to say, if it's old, let's leave it. And if it's new, like here, we want to put up new religious monuments, that's more difficult. So if we summarize Scalia's arguments, he does say, well, in a way, the Supreme Court risks being too divorced from social reality, and religion is still very much present, so therefore we have an issue that the Supreme Court is not very consistent. And we don't really know the line drawing, which way will the court decide. And then we have the originalist critique we discussed. And Scalia also challenges then in Lemon, I don't know what this is, this well-informed observer. So that's his back-fold position, saying, okay, if you want to keep Lemon, at least get rid of the well-informed observer. That doesn't make sense. It's basically just referring to the knowledge the lawyers might have, but not the average citizen. So that would be another criticism he makes of Lemon. Now, when we look at the other case, Van Orden, I said, handed down the same day. Do you see, in terms of the facts, a big difference between McCreary County?
I think personally for me, it was this Van Orden was the monuments more outside. It's like containing a lot of monuments, a lot of historical markers about person identity. It's not specifically linked to being in a courthouse or to the rule of law. It's more about history and culture.
It's a good question. Would it make a difference? Or did the court mention that once it's outside, once it's inside, once it's in a courtroom, once it's elsewhere? Or can you see maybe other differences as well? You said the Ten Commandments there's lots of monuments on the Capitol. I think there's maybe something else also, which I would rather stress, but that's... And I mean, you can see it's a big thing. It's probably much more visible than the, yes.
But it's more passive, and the court also mentioned that the Thomas van On, he walked by for years without complaining, and then suddenly he seemed to realize it. But maybe the difference is also that in this case the monument was there with other monuments as well, and the area was bigger, and that was also okay, now cleaning them up, and someone is coming for the ceremony, and a lot more active in the first place.
So there's one reasoning, basically they said, well, this person walked by for years and all of a sudden complained, so that shows it wasn't a big problem. Do you think that's a good argument or a less good argument?
I don't think it's a very good argument. And when I first compared these two, I did kind of think of the same way as the court, like this seems more passive, but...
What does it mean, more passive?
Well, I guess it's not in your face, because compare it to stone and how in the elementary schools, it was kind of in front of the kids every single day, and so they had to look at it, whereas this, it's around the building, so it's really maybe if you go for a walk around it, you'll see it. Maybe that's what they were getting at with passive. I'm not sure.
So they do mention this passive thing, but what about McCreary County, the third display? You have a lot of elements around it. Is that active or what? I don't know.
I think that for me the difference from it is that in the second case, it is one of many, and they have been there outside of some building, but without a direct connection to what's going on inside of the state buildings. So it's maybe less coercive than hanging up something like this in a court building.
So you mentioned the term coercive, and I will give you my interpretation, maybe I'm wrong. What I think, for me, the main difference is that once you had these three displays, right? Here we have a setting and 20 monuments, so you can make arguably this claim if you're an interior designer. We have, a history of Texas, the 10 Commandments are part of it, and we don't have this history of first you just put up the 10 Commandments and then you come with something else. That made one justice change camp, saying it's not, here we have clearly, we had a religious purpose in McCreary County, not here. But what is interesting, Lemon does not appear. They could have written an opinion saying, look, in terms of the Lemon test says you need a religious purpose, and here we have no religious purpose because we have a more general display. They didn't do that. They talked about a passive monument, wasn't noticed. And so for me, I think what we can feel here, it's more, you mentioned the term coercion, it's the conservative justice who wrote the opinion, so he deliberately does not refer to Lemon. He uses a different framework, and it's more the coercion framework. Saying, well, passive means it doesn't really have a strong impact on you. I think the term passive is a bit, but we'll see that returning when we'll be looking at the impact of the crucifix. What does it mean, a passive monument? So I believe there are factual differences once you have the history, once you don't have it, but that you could still see that it was different justices writing each opinion, the majority opinion. Yes?
What I saw is that these were argued, these two cases, at
The same day.
Is that a coincidence, or?
I think they probably regrouped them, but it is interesting, two cases the same day about the 10 Commandments, and twice 5-4. That was at a time when the Supreme Court had two camps and one justice who was called a swing, who might change camps. And here what happened was really that one justice felt the facts are different. So we can say in McCreary County there was a religious purpose because of this whole history of display, and here, well, we have 20 monuments and it's part of a bigger display. But then it was each time someone else writing the majority opinion and using a different justification. Now question what happened ever since. How do you think Lemon is doing now? What would be your guess? Thumbs down. Clearly it was a case which the conservative justices had a lot of difficulty with. And just to give you then what happened later, so there was a case, First Town of Greece versus Galloway, where it was about, again, you can see a 5-4 decision, very tight at the time. So if you have the opening of town board meetings by the clergy with a prayer, that is not a problem. And you can see actually that here we are also more in a coercive accommodation framework. It does not coerce participation. You don't have to participate, and the argument was a town hall, it's a relatively old practice. Again, how old is something made a difference. It's not school kids, it's not the same as a graduation ceremony. But clearly here we have rather a coercion framework. Then the court decided this, I mean, really big, a cross on its own, etc. But it was erected to commemorate, I think, victims of, I think it was World War I. And basically the Supreme Court said there that it has been there for a long time. Again, it's the ancient practice which played a role in saying, here we have a commemorative purpose, and that it's not obvious to apply Lemon to that. Because here you can't apply the interior designer argument, right? It's clearly just a cross. But the court basically does not apply Lemon, thinking, well, it's been there for a long time. This is the argument Scalia said. At the end of the day, it's just how old something is. And interesting, the argument to say, well, if you remove the monument, that's not neutral. We're back to what is neutral. Is it really not neutral if you say you remove a monument? That would be, in a way, hostility towards religion. And then came the death blow to Lemon in a case where Kennedy was Bremerton School District, where you had basically a coach at a public school football game who insisted on praying everywhere. And you can see him kneeling down and praying. And there basically the court gave up the Lemon test. And ever since, I think we have to assume that this is also what commentators say, that Lemon is dead. And I would just like to end at the end to read to you some excerpts. I hope, where did I put it? I am here, of how Lemon got criticized by conservative justices, for example, Justice Gorsuch, and Alito also saying, for example, a government that roams the land, tearing down monuments with religious symbolism and scrubbing away any reference to the divine will strike many as aggressively hostile to religion. And so here we can see this, this idea, Lemon actually is hostility to religion. And also a quote I found describing Lemon jurisprudence like some goal in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed or buried. Ooh. So very strong, I would say, terms against Lemon. And I think now with the majority being conservative, since this case here, the Bremerton case, Lemon, I think, we'll see, will it be resurrected sometime again? But for the moment, it's buried. It's, as this quote said, lying in its grave. And I'm not sure I should describe it as a horror show thing, but I think it gives a bit the picture. We will look next week at other cases. We will be looking at monuments. We will look at Germany and the European Court of Human Rights, about crucifixes in a school setting, and we will be comparing the reasoning to the one we've seen today. So I wish you a good week still, and see you next week.